Don't panic. I'm here to manage expectations. We said it was a fast-moving story about Donald Trump's tariff policies, that we had a really amazing favorable ruling from the U.S. Court of International Trade just last night, that we had another ruling just a few hours ago from Judge Contreras in the D.C. court. And that you put the two things together and you have two different major courts who have come out and said Donald Trump doesn't have the constitutional authority to impose tariffs, never had it, never will, never did. And then we said there's going to be an appeal. And then we said there's going to be an attempt to get a stay from some court. So Donald Trump, as we reported yesterday, filed his notice of appeal. Filed his notice of appeal with a specialty court that sits in D.C. called the Federal Circuit. Federal Circuit handles patent cases, intellectual property cases, technology cases, and commerce and tariff cases exclusively. So you got to go there. There's about 11 judges there. And we just got a new ruling, as I went on the air right now, from that court in which they've granted an administrative stay. And they blocked, for now, the decision by the Court of International Trade to tear down those tariffs. But I said at the beginning, let me manage expectations for you. I think that's why you come here to Legal AF. You're here already. Hit the subscribe button. Take a receipt as we continue to build this channel. Let's focus. What does it mean to have an administrative stay? All it means is that a court, usually an appellate court, like Supreme Court or just below it, wants to get to the substance and the merits of the appeal and doesn't want to worry about disturbing the status quo while they're doing it. They don't want to be rushed. Appellate courts don't like to be rushed. They're very deliberative. They're usually tortoise-like, not hare-like bodies. Despite what you've watched with the Supreme Court with its emergency docket, they like to go slow. Lots of briefing, oral arguments, deliberation. They get around to writing an opinion on their timetable, not yours. So in order to give them that time, without looking at the merits, they don't even look under the hood to see what the merits of the case is. They just say, we don't want to be rushed. We're going to hold the ring. We're going to put a pin in it. We're going to trap it in amber for the next short amount of time. How long? Who knows? It's sort of like when you used to watch soccer games, what the rest of the world calls football. You never could figure out when the game was over. I mean, now they tell you 16 extra minutes. But before, it was just like, why are they still playing after the 90-minute mark? Well, how many more minutes are they going to play? You never do. Same thing with federal courts and appeal. You never know how long administrative stays are going to last. They last until those judges say they're done. But it is not an indication that they've ruled on the merits and that they're going to overturn the decision by the Court of International Trade. Not at all. But 11 judges that sit in this circuit got together, except for one that recused herself, and 10 out of 11 said, yeah, we're going to put a pin in it. And we're going to consolidate the case. We want one set of briefs. Get your briefs in. Here's your timetable. We'll probably have oral argument. We'll decide on the appeal, I don't know, sometime over the summer. In the meantime, we're going to do a little Heisman move on the Court of International Trade. That's what this means. So I know the headlines are like, court blocks, Trump favored. It's not. It's pretty agnostic. It does not, you cannot read from this. And I can't. I've been doing this 35 years. You can't read from this which way. I would never bet on this. I would not bet my house, my mortgage, the life of my child or my wife on which way this is going to go. Because you don't know. You don't know. When they read the briefs, when they hear from the advocates, when they have time to deliberate and circulate an opinion, they'll make a decision. In the meantime, the tariff scheme took another hit for Donald Trump. Just like, every other day I talk about the Trump administration being blocked, enjoined, stayed, attacked, contempt proceedings started against it because it's lawless, because it's rogue, because he doesn't respect the Constitution. He's making it a doormat. And federal judges are using every power in their toolbox, every tool in their toolbox, along with the Supreme Court, along with the Constitution, to try to constrain and put guardrails around an out-of-control, lawless, rogue president, one who's ferocious in his attack on our institutions and our traditions. And so the law which was created. Remember, we work with precedent. The case law that we're dealing with is already on the books. It's like today's newspaper. It already happened. So they weren't anticipating Donald Trump. I mean, there is some Trump-related case law now because of his bad behavior in the past. But the law is having difficulty catching up to Donald Trump because it wasn't anticipating Donald Trump. The rules of civil procedure and criminal procedure and appellate procedure, which are the Bibles for practitioners, they were written 5 months ago, 8 months ago, 8 years ago, 10 years ago, 20 years ago. They're not built for this either. Federal courts have never seen anything like it except during Donald Trump's run as a criminal defendant. So that's what we're observing. But I don't want you to be disheartened by my reporting about an administrative stay. They happen all the time. I've reported on a half a dozen of them with the United States Supreme Court. Half of those went Trump's favor, the other half didn't. So all it means is that appellate judges don't want to be stampeded into making a decision. And they won't be. And they have a major stop button, pause button at their disposal. It's like you and me with the remote control. They can hit pause. And it stays paused until they're ready to come back and watch television. That's just the way it is. Trump will make, thank God for the federal circuit did the right thing. By the way, the judges on the appellate court that rule in his favor, including the Supreme Court, they're unelected. They're unelected judges, just like the ones he attacks, because that's our judiciary under the federal rules and under the federal process. We don't elect our judges. State courts do. For those that are sort of doing the compare and contrast, the comparative law class here, state courts, a lot of state courts up to the Supreme Court elect their judges. You run for office. You run for retention. We don't do that in the feds. We think that's a right thing. But Donald Trump attacks it as a weakness. Oh, the unelected judges. Compared to me, I was elected. Okay. You weren't elected in any kind of landslide. We just had a controversial former president who was replaced by a controversial person without any, Kamala Harris, without any primaries. And the American voter kind of rebelled. 7 million stayed home and didn't even vote. They didn't give him a mandate. They just kind of threw up their hands on the political process and sat out democracy. Donald Trump is using it to his advantage, and we need to fight back. There's no more do we have the luxury to be the silent majority. We've got to speak up and speak out. We got to talk truth to each other. We start it here on Legal AF. So take a moment, hit the subscribe button here. I'm going to post all of these items under Filings AF on Legal AF, the Substack. And then, of course, we've got Legal AF, the podcast, on Wednesdays and Saturday nights at 8 p.m. Eastern Time, only on the Midas Touch Network. So until my next reporting, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.